Hello, ladies and gentlemen. Today we're going to be talking about the DMV aspect of DUI cases. Now, we have another video that you can refer to on our site that talks about DUIs generally, and we have some other videos that talk about very specific aspects of a DUI defense. But in this video, we're going to be talking about generally the DMV process and what you can expect and why it's important. So Brett, generally speaking, when somebody gets a DUI, there's going to often be a DMV consideration that they have to take into account, and it generally comes in the form of having to request a hearing. And when you request a hearing will vary based upon whether you took a blood test, whether you took a breathalyzer test, or whether it's being alleged that you refused to take a test. So can you first start and walk us through those differences and how that may impact the timing of when you would request a DMV hearing?
It'll make a pretty big difference depending on what all happens on the night in question. So if an individual is stopped and the officer requests that they can perform a test under the express consent law, that's going to change when a person will receive notice that their license is potentially going to be taken. If a person refuses to participate in a test, or if they submit to a breathalyzer and their BAC comes back above 0.08, then they will be served with notice of revocation right then and there. The officer will give the person a piece of paper, take their physical license, and on that piece of paper it'll say, you have 7 days to act. Within those 7 days, the person must request a DMV hearing, or they lose the ability to contest the state taking their license. Now, if a person takes a blood test, there's going to be a lot more delay, and that's just associated with the blood test itself. Whereas a refusal and a breathalyzer, the results are instant. The blood has to be mailed off to a lab, the lab has to test it, then send those results back to the officer, who then sends them off to DMV, and it takes quite a lot of time. Right now, we're seeing approximately 2, maybe even 3 months delay on cases where the person submitted to a blood test before that notice of revocation will come in the mail. And so what we always advise people when they've taken a blood test is to make sure that the DMV has your current address. Because again, once they send that letter, those 7 days start ticking against you. And if you don't request a hearing within those 7 days, you lose the ability to contest the state taking your license.
Okay, so just to underscore what you said, because it's very important for people who are facing the uncertainty of waking up and realizing that they have a lot to do based upon a DUI charge. So you're saying that if the person either took a breath test, which is something that can produce instant results, and if that breath test came in above the per se limit of 0.08, or if they refused or essentially just didn't take a test, then their license is going to be confiscated on the spot. They're going to be given a form, which is called an express consent affidavit. And on that form, it's going to say that you have 7 days to request a hearing. And if you don't request that hearing within those 7 days, then you're going to forfeit your right to contest the taking of your license, and your license is going to go into suspension. But if you took a blood test, because of the just obvious delay that there's going to be involved in that, because the blood's going to have to be sent to a lab, going to have to be processed, going to have to figure out if, in fact, the blood test comes back above that 0.08, it's going to take longer. And if you took a blood test, then you're going to be served notice of the need to request a hearing by mail at the address that the DMV has on file. Is that all correct?
That's 100% correct. Both sides of the coin nailed it.
Okay, perfect. Now, when you request a hearing, there are going to be there's really going to be one choice that you have to make. And that choice is going to be whether you want the police officer who was involved in your DUI arrest, whether you want that officer present or not present at the hearing. And there are some interesting considerations to keep in mind because there's an interplay between when you request that hearing, which has to be at the front end of the process, and when you actually get the police report. So can you tell the viewers about what we generally tell clients in that situation?
In response to the question, do you want the officer present, we advise people to say no. Different lawyers will tell you different things, and so I'll kind of walk you through my understanding of both sides. The lawyers who say yes, I want the officer there, do so for a couple of reasons. Number one, it will seem to the officer like routine procedure. They receive a postcard with the notice of the DMV hearing, and they'll show up on that hearing date. If they don't, you get the benefit of keeping your license, because the officer has to be there to establish the evidence for the state to take your license. And in addition, if the officer is there, we have the ability to cross-examine the officer. And so essentially the idea is the officer won't have his guard up as much if it's just the normal procedure of say yes up front. We disagree with that position because it puts you in the position of having to make that decision by yourself. If you say yes, you will not have seen the evidence against you necessarily in making that decision. By saying no, what that does is gives both you and us the opportunity to review the evidence that is going to be used to potentially take your license. And from that evidence, we can make an informed decision whether we want the officer there or not. For example, if an officer at the end of a long shift makes some mistakes in writing his or her report, I don't want the officer to be present at the DMV hearing to fix those mistakes with oral testimony. I want to be able to point them out to the hearing officer and say, Mr. or Miss Hearing Officer, you cannot take my client's license because of these mistakes. On the other side, if the officer has done a perfect job and it seems likely that you're going to lose your license at this hearing, we then, as your attorneys, can request a subpoena from the DMV. The DMV will issue us that subpoena, we can serve it to the officer, and then we get the benefit as though you had said yes from the get-go. The officer has to be there. If he doesn't, you win and you get to keep your license. If he does show up, we get the benefit of cross-examining the officer. The real only difference at that point is whether the officer is going to maybe have his guard up a little bit more because we've subpoenaed him rather than the normal procedure of just receiving a postcard on his desk.
Yes, and another way of looking at it is that if you request the officer up front, then you're essentially putting all of your eggs in the basket of hoping that the officer doesn't show up, because it is true that if you request the officer up front and the officer doesn't show up, then you get to keep your license through the DMV phase. But if you request the officer up front, it's our belief that you're putting all of your eggs in that basket of hoping that the officer doesn't show up. Whereas the way that we advise our clients is do not request the officer up front, because when you have to make that request, it's going to be at the very front end of the process. You're probably not going to have all of the evidence. Even if you took the blood test and there is some delay, and when you receive the results, it's our experience that generally by the time the blood results come in, you're still not going to have all evidence in your case. So from our position, it's much better to have the benefit of having seen the evidence before we make the determination as to how we want to proceed. Because as Brett says, if once we get the evidence it's deficient, then we are in a better position having not requested the officer and then going to the DMV hearing and arguing to the DMV that there's just simply insufficient evidence to take your license. On the flip side, if once we get the evidence, then the officer's report is perfect or near perfect, at least enough to survive at the DMV, we can still request the officer's presence through a subpoena, and you're not losing anything in the sense that even after subpoenaing the officer, if the officer fails to show up, you still keep your license through the DMV, but you're actually keeping both avenues of prevailing at the DMV alive, whereas if you request the officer up front, you're just going with that one track of hoping the officer doesn't show up. And another really important consideration is that if the officer doesn't show up, not only do you get to keep your license, but the flip side of that is that you might be deprived of your ability to create a really, really good record at that DMV hearing that can then be used in the criminal case. Because when you are requesting or when you're cross-examining the officer at the hearing, they're giving sworn testimony. Is that right?
That is correct. And it's important to kind of talk about why all of this matters. The criminal case and the DMV are typically separate, but sworn testimony from the officer at the DMV can be used to our benefit in the actual criminal case. I want to kind of shift tracks a little bit now and talk about the difference in proof required in the criminal case versus the DMV. The DMV has been created by statute. It's not something where it's a constitutional right to be able to drive. It's a privilege. And so in creating a statutory scheme for allowing someone to drive, the legislature has purposefully made it easy for the DMV to take your license if you are accused of DUI. It's unfortunate, but the standard of proof required is only probable cause. Can you talk a little bit about the difference between beyond a reasonable doubt in the criminal case and probable cause at the DMV?
Yes. So the standard that is needed to be met for the state to take your license at DMV is much lower than the standard that's required to get a conviction of you in criminal court. And that is because one proceeding, the criminal proceeding, is dealing with your constitutional liberty, your constitutional right to be presumed innocent. It's the government's burden to prove beyond a reasonable doubt that you are DUI or DWAI, and that beyond a reasonable doubt is the highest standard in the American justice system. But that's not the standard that is necessary to take your license at DMV because, as you pointed out, the DMV is dealing with a statutory privilege, and as a result, it's not a constitutional right, it's a privilege, and the standard for the state taking that privilege away from you is much lower. So at the DMV, the requirement is that the state be able to prove that one, that you were stopped for a valid basis. Two, that upon being stopped, a reasonable officer would believe that you were probably impaired. And three, that the test came back above the legal limit or you refused. All of those three considerations at the DMV hearing have to be met by a preponderance of the evidence. Which is another way of talking about the standard of probable cause. It's essentially more likely than not. Probable cause, you're talking about an offense probably happened and you were probably the one who did it. It's the same idea with preponderance of the evidence, which is, something is probable. It's more likely than not. So for the state to take your privilege to drive at the DMV hearing, all they have to do is prove by a preponderance of the evidence, or more likely than not, that one, there was a valid basis to stop you, two, that the officer was reasonable in believing that you were probably impaired, and three, that the test came back above the legal limit, or that you refused. If the state can prove by a preponderance of the evidence those three things, then they will take your license, unless the officer fails to show up at the hearing. So that's why just because you may not have a successful outcome at the DMV and you may lose your license, that doesn't necessarily by any stretch of the imagination mean that your criminal case, which has a much higher standard, can't still be defended successfully.
And I think a relevant question that arises at this point is, how long is my license going to be taken if the state does take my license? On a first offense where a person submits to a chemical test and that test comes back below 0.15, you are in the best possible situation. You will, if the DMV does take your license, you will have to go 1 month without driving. During that month, about 2 weeks into that month, you'll want to meet some requirements in order to get your license back. Those requirements are SR22 certification. That's where an insurance company sends certification to the state that you carry the minimum liability coverage required by law. You'll have to have an interlock device installed in your car. That's just a breathalyzer. And it's very important because if you are able to have 4 consecutive months of clean blows, and I mean zeros, on that interlock device, you'll be eligible to take it out early. If you have any problem with the interlock device, meaning a hot test where it detects any amount of alcohol, you will have to have that interlock device in for a total of 8 months, serving out a total of 9. 1 month of no driving, 8 months of interlock. That's if you mess up the interlock. If you're perfect on the interlock, it's 1 month of no driving plus 4 months on the interlock.
So tell me if I have this right. If you are on a first offense and the BAC is below 0.15 and you lose your license at the DMV, then the consequence is going to be 30 days no driving, followed by 8 months of interlock, but you can get that interlock reduced to as little as 4 months, so long as you haven't had any issues with that interlock device.
Correct.
And then if you are above 0.15, or if you are on a second or subsequent, then it's going to be a more involved process.
Correct. Yeah, that persistent drunk driver status that the DMV assigns also applies to second or subsequent revocations. They're not concerned with charges, they're actually concerned with action that the DMV takes. So if you're on your second and you lose your license, you're going to have, again, depending on your BAC, 1 month of no driving with 23 months of interlock device, or you're going to have 2 months of no driving with 22 months of interlock device.
So this is obviously a lot of moving pieces, and this is exactly why when you are facing a DUI, you shouldn't go it alone, even if it's a first offense, because you're dealing with not only the criminal side of things, which is going to be concerned with what may be on your record. Are you going to have to do any jail? Are you going to have the type of conviction that is going to perhaps haunt you in the future? But it's also going to be dealing with the DMV and what's going to happen with your license and how long you might have to take any steps to get your license back to normal status. And so for that reason, it's always advisable to have an attorney who knows what they're doing, like we at the law office of Jacob Martinez fit that description, to help you through the process and ensure that anything that happens in the case is done with attention to detail to make sure that no stone is left unturned in our efforts to try to not only keep your record clean, but also help you and with the DMV so that the consequences to your license are minimized.
Agreed.
All right, well, thank you very much for listening to this video and watching this video, and please feel free to check out our other videos related to DUI and other topics on our YouTube channel. Thank you.
Thank you.